During a bond hearing in Okaloosa, Florida, Zera Bell faced serious charges after being stopped with fentanyl, a firearm, and over 80 concerning text messages to his ex. Watch as his defense attorney argues potential civil rights violations related to the stop, followed by the judge's final decision. Yes.
Now we have closer.
All right. Is everyone ready on Bell?
Yes, Your Honor.
All right,
Yes, Your Honor.
All right. So Mr. Bell is here on two separate cases. That's 25 CF 699, where he was arrested for trafficking in fentanyl, possession of a weapon or ammunition by a convicted felon, possession of narcotic equipment, and use or display of a weapon during a felony. And the second case, I don't believe is here for pretrial detention. It's aggravated stalking. Although, are you seeking it in that case as well? I didn't see a motion, Ms. Herndon.
Your Honor, and I'm just looking at Ms. Leone's. I think that it was under both, but honestly, the state intends to call Officer Jonathan Norton. The victim is present in court, but we're going to present Officer Norton.
Okay. Aggravated stalking is listed under 907-041. 5A17. So it is under both particular cases.
Judge, if I may, the motion does have both case numbers on it, but paragraph 3 alleges that in the aggravated stalking that he's charged with attempted premeditated murder. And I don't see that. I just see the aggravated stalking. I don't know the state's. When I looked at the clerk's file yesterday, don't believe the state had filed an information.
I anticipate that's a Scrivener's.
All right. So I'm looking at the motion. It says the defendant is currently charged with attempted premeditated murder, aggravated stalking by credible threat and use of two-way communication device to facilitate a felony in 25 CF 698. It's a rather large one, but the attempted premeditated murder is a Scrivener's error.
Yes, Your Honor.
Okay. So we're all clear that that's not being charged, or at least hasn't been charged at this point. I don't know anything really about the facts of Mr. Bell's case.
Thank you, Judge.
All right.
Your Honor, we're ready to proceed with Officer Norton.
Okay. How many witnesses do y'all have?
I anticipate just calling Officer.
Mr. Williams, do you have any witnesses here?
No, Your Honor.
Okay. Officer Norton. Was she on the docket? You raise your right hand, sir. You swear or affirm that the testimony you're about to give is the truth?
Yes.
All right, take a seat there. Make sure you speak into the microphone for us.
Yes, sir.
All right, go ahead with your questions.
Would you please state your name for the record?
Officer Jonathan Norton,
Who are you currently employed with, officer?
Crestview Police Department.
And how long have you been so employed?
Approximately 1 year.
I'd like to turn your attention back to April 5th. Did you have contact with a woman by the name of Kirsten Grice?
Yes, ma'am.
And what was that contact regarding?
Messages between herself and her ex-boyfriend, the defendant, Mr. Bell. She was concerned about some of the messages that he had been sending her over the course of approximately 4 days. They've been kind of escalating during that time frame, becoming a little bit more frequent and threatening in nature. And she was concerned for her safety. I had spoken with her. She had mentioned that she wasn't able to go home and she was kind of scared for her life. So I made contact as soon as I got on shift and I was able to, and I reviewed some of the messages.
Did she provide those to you from her cellular phone?
Yes, ma'am.
And in your review of the messages, what did you note?
I just noted that the in the very beginning, when she first had trespassed him from the property, and asked law enforcement to intervene to try to remove him from the home and verify that he wasn't in the home. Right when that happened, he started messaging her approximately 5-10 times, long paragraph messages, very long messages. I can't recall off the top of my head some of the earlier ones, but she was just consistent in her replies. Please stop messaging me. Please stop messaging me. And as the days kind of continued on, they were throughout the evening, throughout the nighttime, kind of suggestive in nature. Whenever she would leave the home, he would, "Where are you going? I know where you're going." And some of them were threatening in nature, mentioning, I believe, one of the sections I quoted him on was that he was going to murk her.
Judge, I'm going to object to conclusory testimony. I mean, he's basically drawing conclusions about what he saw, but he's not actually providing the court with the evidence, what the message is.
You're presenting the text messages?
Your Honor, not at this point. We don't have the ability to, they're in the process of being transferred, but I was not able to get those downloaded for the court today.
I apologize.
Let's keep it to anything that's
Sure.
actually a quote as opposed to
Sure.
what he paraphrases it to me.
And let me ask you, Officer Norton, during your conversation with Ms. Grice, was there a concern regarding the defendant showing up at her residence when she was not there?
Absolutely. She was concerned. I believe at the time she had mentioned that she couldn't locate her additional house key, and some of the property on her property had been moved. Specifically, there was a chair that was moved from the front yard into the dark, bushy section of the backyard. And I believe that he had mentioned that something along the chair, they had a conversation regarding the chair. So she was very concerned that he was visiting the home while she wasn't there. And it kind of made her to the point where she didn't want to return to the home.
Do you recall approximately in this 4 to 5 day period that these text messages were taking place, approximately how many messages the defendant sent Ms. Grice?
In excess of 80.
In those messages, did you see confirmation from Ms. Grice where she asked him not to contact her?
Yes.
Did the contact continue after that point?
Yes.
Did Ms. Grice relay to you how she felt about receiving these messages?
Yes, ma'am. She was in extraordinary fear. She'd mentioned she left her child with a family friend because she was concerned for having her child around her safely. I'd forwarded her to our victim advocate, and I was trying to find every resource that I could to assist her.
Okay. Let me ask you, Officer, based on your investigation regarding statements, did you go to make follow-up or have contact with the
I attempted to locate Mr. Bell a couple times prior to the realization of these current charges. I had been trying to make contact with him regarding some of the circumstances regarding the trespass. After she had brought these concerns up and I reviewed the information, I attempted to canvass the surrounding areas where she mentioned he had been known to frequent to attempt to interview him and talk with him in regards to this.
At some point, were you able to locate him?
Yes, ma'am.
And can you tell us just briefly what happened in that?
Yes, ma'am. Upon locating him, I got out of my Crestview issued patrol vehicle, dressed in exactly what I'm wearing today. I confirmed his identity by calling out, "Hey, Zera Bell, I had to ask you a couple quick questions." He turned around. We spoke briefly regarding some of the issues regarding the trespass. At that point, once I had confirmed his identity and I knew that it was him, I asked him if he had any weapons on his person, based solely off of some of the statements that the victim had made in her initial affidavit of complaint, some of the firearms that he had on his person, and he had a backpack on him. He didn't want to answer. I requested him to take his back.
I'm going to object to move to strike in a refusal to answer questions. He's not required to answer any questions of law enforcement.
Did you ask him to remove the backpack?
Sustained and struck. Go ahead.
Officer Norton, did you ask him to remove the backpack from his person?
Yes, ma'am.
At some point, did he comply?
No, ma'am.
What happened next?
When he refused to remove the backpack, myself and Corporal Sprague, we attempted to restrain his hand movements by grabbing a hold of his wrist and utilizing a custodial grasp. And I did inform Mr. Bell that he was being detained and that we could discuss some of the questions that he had as soon as I had him secured. He did brace his body against myself. He pulled frequently. He didn't want to comply with my lawful orders at that time. As we got his hands behind his back, we did pull the backpack off and I secured it with myself. So we relocated back towards my patrol vehicle due to the large crowd that was gathering. We had him secured in the back of my patrol vehicle.
Okay. At some point during this detention, did you look inside the backpack that was on him?
Yes, ma'am. I searched his person.
It's not been established that it's a lawful search.
Certainly we can.
I think evidence that is obtained in violation of the Constitution is specifically talked about that. I'm not making a ruling that it has been, but I think a predicate has to be laid.
So let me ask you, I believe you stated that you placed him in the back of the patrol car?
Yes, ma'am. So prior to placing him in the back of the patrol car, because he was being placed under arrest at that time, I conducted a search incident to arrest.
What was he being arrested for?
He was being arrested for the aggravated stalking as well as the use of a two-way communication device to facilitate a felony.
And after he was placed under arrest, you said that you searched incident to arrest. Well, let me start with him. Did you search?
Yes, ma'am. Prior to searching his backpack, I conducted a search of his person.
What, if anything, did you discover?
On his person, I found a blue Apple cell phone as well as a small plastic baggie containing a white powdery substance consistent with drug paraphernalia.
Did you field test that substance?
Not that substance, ma'am.
Okay. Did you find anything else?
Yes, ma'am. Once we searched his backpack, we found...
Judge, I'm going to object. It's not been established that's even a valid search incident to arrest. He testified where he placed the backpack, but nobody's testified as to whether or not he was in a position where he could still obtain a weapon or easily destroyable evidence from the backpack. At that point,
let me just stop you, Mr. Williams. If you want to argue further, but from what I heard the testimony to be, he was being arrested for aggravated stalking based on use of a cell phone, which was also the second charge, use of a communication device to facilitate a felony. So looking for the said cell phone in the backpack, which is where officers said he found it, I think is more than reasonable.
My argument, Judge, is under the recent change to the search incident to the arrest law. If we go back to the original rationale, you either get a warrant for it or it's got to be where the defendant can obtain a weapon or easily destroyable evidence. And if it's in the back of the police car, it's just not.
I understand, but if it can still be evidence of the crime for which he's being arrested could be found during that search, I think it's reasonable. I think you're referring to the Arizona versus Gant Supreme Court case, which was a driving while license suspended, where the court specifically said they weren't going to find any other further evidence of the crime, that being driving while license suspended, inside of the person's backpack or other.
Yes, sir. Schimmel is based on the defendant's ability to obtain a weapon or easily destroyable evidence. They have the backpack in their possession at the point based on this officer's testimony. It is locked in his police car. He doesn't have access. The defendant doesn't have access to it, doesn't have the ability to obtain easily destroyable evidence from it. So I'm objecting to introduction at this time with this predicate of that evidence. I mean, if we need to, we can have a motion to suppress hearing on it later. But just in terms of today's proceeding, I'm objecting.
Any response concerned?
Your Honor, I think a phone is easily destructible device. It is something that has to be switched into airplane mode in order for a warrant to be done. I don't believe that argument has any merit.
Okay. I'm going to overrule the objection, Mr. Williams.
Officer Norton, when you searched the backpack, what did you find?
Upon opening up the backpack, we found a firearm inside of the backpack that was consistent with the victim's statement. She had mentioned 2 separate firearms that he's known to carry on his person. The first she had mentioned was a AR-style rifle that he keeps in his waistband. The second, she had mentioned it was a .380 style handgun with an extended magazine. Right when I opened the backpack, I saw what I believe it was a Taurus 9mm with the extended magazine.
And did you find anything else that was contraband?
Yes, ma'am. We found a large container, plastic container with a white powdery substance, as well as approximately 10 more bags consistent with the one that were found on his person. Field tested the substance, and it field tested presumptive positive for fentanyl. There was also a yellow Dollar General bag that was in his backpack. It was torn up. He did have... There was one small section of the bag that he had torn off, and it had a prepackaged amount, approximately less than 1 gram of the same substance from the bottle, which again, field tested presumptive positive for fentanyl.
Officer Norton, during the investigation or during this transaction, did you get a presumptive weight for the substance that was found in the backpack?
Yes, ma'am. The initial total package weight was, I believe, 54 grams. I did go back and reweigh the actual, just the powder or the white substance, and I believe the final weight was 38 grams. I would have to double check with you on that one.
Sir.
But we also did find the cell phone as well in his backpack.
Thank you.
All right, Mr. Williams, Ross.
Of course, we don't have FTLE reports back on any of that, do we?
Not at this time, sir.
Okay. And did you zero the scale prior to testing the white powder? And what did you place the white powder on, and how did you zero the scale?
So, yes, sir, I turned it on. I made sure that it was zeroed out. It showed no weight on the scale. And then I weighed the substance.
Did you put the substance on lab paper?
So initially, sir, no, I didn't place any paper or anything on it because it was in the closed container and I didn't want to open it based on the fact that it was a very fine powder. I didn't want to take the opportunity or the chance.
Right. So you weighed it in the container?
Yes, sir, which is why I said the total package weight.
All right. Nothing further, Your Honor.
No redirect, Your Honor.
All right, you can proceed, officer, or you're free to go.
Oh, I'm nervous.
You're okay. Mr. Williams. I'm sorry, Ms. Herndon, no other witnesses. I made that assumption. You said one witness earlier, Mr. Williams.
No witnesses, Judge.
Okay. Argument, Ms. Herndon.
In this case, Your Honor, the defendant has been charged with 2 crimes that are classified as dangerous felonies under the statute, the aggravated stalking as well as the trafficking in fentanyl. The testimony was uncontroverted and pretty clear regarding some messages that were coming through over a several-day period of time that were threatening in nature that continued when Ms. Grice had asked the defendant to stop. When the officers made contact with Mr. Bell and detained him and placed him under arrest, the testimony was clear that there was a baggie with residue in his front pocket. Then there was a trafficking amount of fentanyl, even in the no package weight where Officer Norton testified that he had weighed after at 38 grams is still in excess of 28 grams. There was also a firearm located with that. Your Honor, based on the fact that Ms. Grice is in fear of Mr. Bell, that the messaging continued after he was asked repeatedly to stop that contact, we do not believe that there is any kind of restrictions that short of detention that would ensure the safety of Ms. Grice, along with the fact that obviously Mr. Bell was found in possession of a very large amount of fentanyl along with a firearm and packaging that was consistent with distribution. Based upon that and the danger of the community, the evidence, obviously the state has proven a substantial likelihood that the crime has been committed. We are asking that pretrial detention be placed on Mr. Bell.
All right, Mr. Williams, your argument.
Thank you, Judge. Judge, most of the evidence you heard today was conclusory from the officer. No text messages were admitted into evidence. No messages were even read directly from the phone. In terms of the, we had a discussion in the earlier case. The status of the law is right now is that the regular rules don't apply of evidence, but nevertheless, I think the court can take that into account in determining whether or not the burden has been met, that although essentially the hearsay evidence is admissible, it's generally given lesser weight. In terms of, more specifically in terms of weight, we're just going to have to wait and see what FDLE comes back with, even though if this is fentanyl. We are starting to see some cases where substances are reacting to the presumptive tests that law enforcement does and are then coming back from FDLE, no drugs identified. Certainly, the court's aware that the mixture rule does not apply when we're talking about packaging. And FDLE will do a proper lab weight. They'll zero the scale with lab paper on it and then test just the substance.
Did I miss a portion? He said he measured it with the packaging and then without the packaging, right?
He did, Judge, but when I started asking him about zeroing the scale and whether or not he used any lab paper, we kind of got on a totally different track. He didn't seem to know what I was talking about. So I'm going to suggest we need to see what FDLE comes back with. Plus, again, we don't know that his presumptive test is actually going to be accurate in this case. These have not been accurate in all cases.
Continue with your argument.
So, Judge, based on that, I'm going to ask that the court give him a bond, and then we can discuss the parameters of that bond. Certainly in terms of protection of the victim, a GPS, active GPS with an exclusion zone is normally used in domestic violence, stalking cases of that nature. Thank you, Your Honor.
Anything else, Ms. Herndon, from the state? Okay. All right. Now, obviously, I said some of these things are in the last case, but every case has its own record, so I have to repeat a few things. Under 907-041 Florida statute, paragraph 1C, 5C, states that upon a motion of by the state attorney, court may order pretrial detention if it finds a substantial probability based on a defendant's past and present pattern of behaviors, criteria 903-046, and any other relevant factors that any of the following circumstances exist. Obviously, we've got two different cases involving two different counts in those cases that could lead to the pretrial detention. C3 states that the defendant is charged with trafficking and controlled substance as defined by 893.135. There's substantial probability that the defendant has committed the offense and that no conditions of release will reasonably ensure the defendant's appearance at subsequent criminal proceedings. Specifically going through the facts of this case, there was found what, from my memory of what the officer testified, approximately 38 grams of suspected fentanyl, that it was positive on it's often referred to as a presumptive test. Of course, there's no lab reports back. Florida Department of Law Enforcement doesn't exactly get those back within 5 days, which is the requirement as to how fast this hearing has to come. So we are going forward just on the evidence that's here. So I will find there is substantial probability that he committed the offense. It was on his person at the time in the backpack that he was being arrested for the other case. And then going through the what I didn't hear is a whole bunch of information regarding his past and present patterns of behavior. I don't know if Mr. Bell has a prior history. And as far as the criteria of Florida Statute 903-046, as far as his connections to the community, length of time in this community, family ties, immigration status, employment history, financial resources, or mental condition, which are things I'm supposed to take into account under that particular statute. I didn't hear evidence on those. And as far as there being no condition of release, which will reasonably assure that the defendant's appearance at subsequent criminal proceedings, I didn't hear any evidence of any concerns about flight or any failures to appear in his record. As far as the other charge, which is the aggravated stalking, Again, that's going to be 907-041C5, that the defendant poses a threat of harm to the community. Court may so conclude if it finds that the defendant is presently charged with a dangerous crime, if there is substantial probability that defendant committed such crime, that the factual circumstances of the crime indicate a disregard for the safety of the community, and there are no conditions of release reasonably sufficient to protect the community from the risk of physical harm to persons. I kind of said that's what applies to the aggravated stalking, but I think certainly it could be applied to trafficking in fentanyl. Certainly that poses a harm to the community. Those both aggravated stalking and trafficking in fentanyl are both dangerous crimes. I find there's a substantial probability that the defendant committed such crimes. Again, the officer didn't talk about every single text message, but did give enough testimony to explain what they were, despite being told repeatedly to stop texting. The evidence was that there were 80 text messages over a short period of time, that many of them were lengthy, sometimes paragraph or more long, and the content of them was sufficient to be considered a credible threat. That the factual circumstances of the crime indicate a disregard for the safety of the community. Obviously, that there are safety concerns for the victim in the aggravated stalking, and I believe trafficking in fentanyl certainly disregards the safety of the community due to the fact that it's well known how lethal fentanyl has become, and not just this community but across the country. Also, as far as conditions of reasonable of release that are reasonably sufficient to protect the community of the risk of physical harms to persons, we've got a situation where there's a charge and a substantial probability of committing the dangerous crime of trafficking fentanyl, which is a danger to persons, as well as the threats and aggravated stalking that went into that charge as well. So based on my findings of fact and applying those to the law, the court will hold Mr. Bell under pretrial detention in both cases until further order. I'll have that order to you later today. Obviously, we have a large docket to get through still.
Yes.
Okay. Yeah, we've got to do Crooks next. The Crooks is not a hearing now.